I'm Noah Shapiro-Franklin.
I'm Sarah Marks.
And I'm Leah Kayali. And the title of our performance today is Reed vs. Reed, the pivotal catalyst to legal equality for women.
We demand equality. When do we want it now? We demand equality. When do we want it?
The sun is shining and we are here in D.C. on October 19th, 1971. I am now outside of the Supreme Court as we anxiously await the verdict of the Reed vs. Reed case. For those of you just tuning in, this case is a dispute between a divorced couple over the estate of their deceased son. This argument started when tragedy struck the Reed family. The prosecution is using the 14th Amendment to uphold their argument, saying that women should be protected under the Equal Protection Clause. America, this might be the first time that women will be protected against discriminatory laws under the 14th Amendment of our Constitution. As you can see, protesters over here rally behind Sally Reed as an important part of the feminist movement sweeping the nation.
4 years earlier, in 1967, Sally Reed decides to take initiative.
Hello. Hi, Daisy. Yes, I was in court last week. Can you believe that's Cecil in the case? It's just unfair. You know, when Skippy was only 3 years old, Cecil left her family. I single-handedly raised my son and turned my home into a care center for the mentally disabled in order to make ends meet and to be able to raise my child. Daisy, I deserve the property, and I will be appealing to the district court as soon as possible. I feel that I must take action for my son and for myself. Have you read the latest article in Ms.? Women still make 63 cents to a man's dollar. It's finally time we step outside of these traditional gender roles. Daisy, this can be a great opportunity to gain rights as women, for you, for me, for all of us. Bye, Daisy. Thank you so much for taking my case, Miss Ginsburg. It means so much.
No, thank you, Miss Reed. You see, it's women like you who bring our gender closer to legal equality. Now tell me how this all started.
Well, throughout his childhood, I had custody over my son, but when Skippy reached his teenage years, Cecil received partial custody. A few years ago, I received the worst call of my life. Skippy had been shot with his father's rifle, and it turns out later that Cecil had taken a hefty life insurance policy out of my son just prior to his death. This leads me to believe the worst, which is just another reason why I deserve my son's property. I know he would want me to have this.
From what I understand, the reason that you were unable to achieve this property is due to the fact that the Idaho Probate Code says that men must be preferred. So what you're saying is they didn't take into account your qualifications as your son's guardian and therefore rightful owner of the estate?
That's true. Cecil walked out on us. He left my son and I alone, with nothing. He took everything. I won't let him have this too. And I find it infuriating that our government is neglecting to acknowledge my rights due to this arbitrary and sexist law.
You're right, Ms. Reed. The fact is that this law does violate your rights under the Equal Protection Clause of the 14th Amendment, and this will be essential in lobbying your case.
Miss Ginsburg, tell it to me straight. What are my chances of winning the case? Has anything like this ever happened before?
Truthfully, no. In the past, women have been unable to obtain their rights by means of the Equal Protection Clause. The judge on the case of Bribel versus Illinois said that women's natural delicacy made them unfit for many occupations of civil life. But even more recently, in case Hoyt versus Florida, Gwendolyn Hoyt said that she challenged Florida's all-male jury laws, except the Supreme Court said that that law was not unconstitutional. But Sally, times are changing. Just look around you. 5 years ago, the National Organization for Women was created. Women are demanding a larger role in our society and control of their own destiny. And Miss Reed, you and I represent everything that this movement is. I have faith that we can win this case and turn the tide for the women's fight for equality once and for all.
Welcome back, folks. I'm here with Sally's lawyer, Ruth Bader Ginsburg. Would you mind describing the events that brought the Reeds to these very steps of the Supreme Court?
Certainly. Both Sally and Cecil Reed petitioned to be the administrator of their now deceased son, Richard, known as Skippy's estate. However, when the probate court deemed Cecil the administrator, this family quarrel turned into arguments at both the district and state courts, who reached the same verdict. But Sally Reed kept fighting. She appealed again and brought her case to the Supreme Court, where we now stand. Ms. Reed and I are hoping to win this case by proving that women are equally entitled to the provisions of our Constitution.
So, are you saying that Sally is no longer fighting for the property, but for the principle of equality?
Exactly. Yes, this is no longer about the petty estate. It's about the women's liberation movement.
We know your time is short and you need to head back into the courtroom, but we can't thank you enough for speaking to all of us today. Stay tuned as we await the final arguments and verdict of the case. You may be seated. This court is now in session. On this day, October 19th, 1971, we are appointed to determine if a mandatory provision of the Idaho Probate Code 15314 is based on discrimination and therefore violates the Equal Protection Clause of the 14th Amendment. First, we will hear an oral argument from the prosecution, Ms. Ginsburg, then the defense, Mr. Stout, and finally the prosecution will have time for a brief rebuttal.
We are here today to ask you, the courts, to do something that these courts have never done since the 14th Amendment was adopted in 1868, and that is to establish classifications between males and females as unconstitutional. A mother was denied the right to keep the estate of her deceased son due to an existing probate code that says, and I quote, "Of several persons claiming and equally entitled to administer, males must be preferred to females," end quote. Because of this, my client was unable to obtain even this measly $600 property. Simply, the decrees on the basis of this Idaho probate code are clearly unjust, and they infringe upon her rights as stated to everyone under the 14th Amendment of our Constitution.
Our job today is to examine this probate and determine its constitutionality. It is our position that this particular statute is not unconstitutional. For the last 125 years, the probate court gave preference to the male applicant when the two contenders had equal ability, such as in this case, a mother and father. I think that at the time this statute was enacted in 1864, men as a rule were better qualified than women. And considering the length of time this statute has been so successfully in effect, this elusive provision of the 14th Amendment is simply not enough to declare it unconstitutional.
I think that the demolition of this statute could now solve that situation by allowing women to take their full place in our society, to take advantage of the opportunities available, and of course to take the responsibilities that always go with opportunity. And justices, I will leave you with this. Is that not the fundamental principle of fairness that our country and our Constitution stands to protect? Thank you.
Welcome back, folks. We have finally received the long-awaited verdict of the case, and here it is. We unanimously declare that the mandatory Idaho Probate Code 15314 is based solely on discrimination and therefore violates the Equal Protection Clause and is the very kind of arbitrary legislation that our Constitution stands to protect from.
The aftermath of my case was monumental and affected our nation more than I could have ever imagined. This case was successful because it was evident to those justices that men and women were not held to an equal rights standard. On July 1st, 1972, the verdict of my case was put into effect when the probate code was repealed, and I finally received my son's property.
This case set the standard that courts must address gender discriminatory laws at least on a case-by-case basis. The same legal practice was used in other cases such as Frontiero v. Richardson in 1973 and Craig v. Boren in 1976. The court used the verdict of Reed v. Reed to uphold their argument and further abolish sex classifications.
Just 20 years after this critical case, I was appointed a position on the Supreme Court, and now here I am at the University of Maryland School of Law to talk about how far we've come since that momentous day. One of my first and most important cases in this long fight for adequation was Reed v. Reed. It gave others the opportunity to use the 14th Amendment to gain equality, and that gave some feminist hope that a new constitutional amendment would be added to serve that purpose, though that never came to fruition. Reed v. Reed made the ideals of many feminists become reality. It led to the involvement of women in many aspects of society. Women became business workers, educators, and politicians. Let it be known that without Reed versus Reed, American women may have never been able to reach the level of equality that they are granted today. Thank you.
Thank you.